Good morning, everyone. As usual, welcome to the Saturday morning webinar, knowledge sharing webinar organized by Mehta and Mehta. Today's topic is an insight into the reduction of share capital, including taxation and accounting aspect. Today's presenter is Mr. Dwip Joshi, a legal consultant to Mehta and Mehta. And today's panelist is Mr. Atul Pandey, the company secretary and legal head, XIII Industries Limited. Welcome, Mr. Atul.
Thank you, ma'am.
To formally introduce Mr. Atul Pandey, Mr. Atul Pandey is an associate member of IPSR, having more than 8 years experience in field of listing compliance, secretarial, board management, and legal. He holds master's degree in commerce, bachelor's degree in law, forensic certificate from West Virginia University, IPO certificate from ICSR. Currently, he is working as a company secretary and legal head at XIII Industries Limited. Welcome, Mr. Atul. Thanks a lot for your time.
Thank you, ma'am. Same here.
We have with us, of course, our own today's presenter is Mr. Dwip Joshi. We have with us Mr. Bala as our own. You know everyone, Mr. Bala is a company secretary having almost 4 decades of experience in secretarial compliance and worked in Foseco India Limited and is a regular speaker at ICACI CCGRT and contributes various articles in Charter Secretary and various other forums. His recent article is on placing penalty for not numbering the number of AGM in notice and agenda of AGM. That is a recent few days back. Welcome, Mr. Bala, as usual, our moderator. Our today's presenter is Mr. Dwip Joshi, who is a legal professional and consultant to Mehta and Mehta. Mr. Dwip Joshi is a company secretary and is a Bachelor of Law, and he is associated and he is in practice for more than 5 or 8 years. Welcome, Mr. Dwip. Mr. Dwip, thanks. We have with us Ms. Harshida. She is associated with Mehta and Mehta as a accounts and finance head. She is going to present accounting and taxation aspect on the topic. Friends, as you know, we are now started to present accounting and taxation aspect of each topic so that CS will have both the idea, and to our happiness, we have a lot of CA participants also, our professional CA colleagues. So it solves many issues involved in the topic. So I'll request Mr. Atul to say a few words on the topic, then Mr. Bala, and then we can start the presentation. Friends, as usual, put your questions in the chat box. It will be taken at the right time. And at the end of the session, the participant who raised the hand will be allowed to speak. Over to Mr. Atul. Thank you.
Thank you, ma'am. Thank you for this opportunity. Good morning, everyone. My name is, Atul Krishna Pandey. I'm working as a company secretary and legal head. And as per my view and my experience of reduction of share capital, so I faced few challenges like NOCs from the creditors, because we did a reduction for the manufacturing unit. So we have a lot of creditors. We had a dispute as well. So it is very difficult to convince them about the reduction. So we have to tackle them to get the approval to the deduction. So we separated them and had a meetings with them, and we tell them that it will not affect them financially, and share with our plan with them and told them how it will be happen. So, and apart from this, we have a second hurdle is like for the shareholders approval. So being a listed entity, we have a listed entity, lots of outsider shareholders, and their few shareholders is very critical and very, very difficult to handle them. So, like, we have to tell them ki how important is for the company and for them. So, how we handle, because I handle around 500 shareholders at that moment, and they are like over on me ki why you are doing this, why you are doing that. No, मैंने कहा भाई रुको 2 मिनट रुको. Being a TV wala, you have to handle every kind of, there are some professionals, there's some retailers is there. So they are just like you can say like परचून की दुकान कि सब आ रहे हैं माल खरीदने के लिए, and they are asking why you are doing this, why are you doing this. So we have to tell them कि how did we affect the company and them also. So likely our chairman told me कि you handle it very well. And it is very important to tell someone who is not related to the company about the scheme. Like if we are a promoter and we tell them that we are doing this, तो सबको लगेगा, कि like they have some hidden agenda as well in there, and so they told me that you have to handle, and one of our independent director is also handle the same scheme. And third one is we handle the authorities. We have few matters with the income tax department is there. So we send the scheme and they uh, issue some notices and points why you are doing this. So when we present them the NOCs from the creditors and tell them the accounting treatment and anything, they give us the NOC for the same. And then we go for the NCLT and get the approval of the same. This is how I done the reduction.
Okay, thank you, Mr. Atul. Mr. Bala, over to you. 1 minute.
Good morning to all of you. I have a great pleasure in welcoming you to this particular topic. Although this particular topic is not a very common topic when we are talking about it. Because normally when we talk about the capital reduction means simply in a common understanding, reduction of the company's share of the company. That is the thing. Equity shares. Why it is being done? Because there are many reasons for doing the thing, because probably they want to do the capital restructuring, that is one of the reasons. Or they have a lot of surplus money, etc., which they want to return back, unwanted money to the shareholders back. Or they want to create for the future reserve in order to give the dividend. Or the company has got accumulated losses over a period of time, which does not represent the real capital versus assets what they are holding. These are all the issues which are actually there. Although the capital reduction can be achieved in many ways, such as, going for the demerger or buyback of the share or returning the excess capital, etc. But yet, if you really want to reduce the capitals and going through the process, in which case you have to go to the NCLT. Buyback, another thing, we don't have to go to the NCLT, whereas in this particular case, we'll have to go to the NCLT, we'll have to make out the proper application of the framework of the Companies Act. Anything which is actually done, it should be performed according to the laid down laws and rules, regulation, which has to be there. That is why we are actually here. And today we have the greatest advantage of having two people, one person who is with a listed company who handle the capital reduction issues, gone through all this procedure from the point of the company's point. Another thing is there having a practicing gentleman who is associated with the NCLT. And incidentally, he also happened to be our own company secretary faculty who would be able to apply both. What is the importance of company secretarial function? What are the rules? What are the regulations? More than anybody else, because we are the core professionalists in this area. So we have both the advantages today for the presentation. And Mr. Joshi will be actually presenting. He will take us through the procedural aspect which are actually involved in achieving the capital reduction. I think Atul will add his own experiences and other thing and all. And I also would like to say that this is the master class of the series we are discussing relating to the capital reduction. Of course, for the listed companies, etc., the SEBI LODR regulations are applicable. There are n number of procedural issues which are actually involved. We won't be discussing elaborately those, but nevertheless, LODR regulations are required to be adhered to. Because normally when you formulate this sort of the scheme, the draft scheme itself is to be given to the security exchange authorities, and they'll have to go through the things, And they will ask many questions. What is happened? What is the future after the capital reduction? What will happen before the structure, after the structure? All those things they will look into the perspective, because ultimately the SEBI's preamble says, to safeguard the interest of the investors, that also small investors. So from that perspective, they will look into it, because ultimately they have to give a no objection certificate for going ahead with the capital reduction. Of course, you will be touching upon what are the things which are involved in the LODR regulation, but we won't be discussing in detail the LODR. We'll be mostly concentrating on the Company Act's point of view. But nevertheless, this is also equally important. That is all I want to say. Nothing more than that on this topic. So let us hear the expert on this topic so that we'll have better idea. As Dipti puts it, please keep raising your questions and clarification what you need in the chat box. We will be taking from the appropriate time. At the end, of course, we can discuss it if anybody wants to raise the question, etc. That we'll do it. Yeah. Okay. Over to Dr. Joshi, please.
Yeah, we'll start sharing the screen.
Are we able to see this?
Yeah, very much. Before you started the topic itself, the question has started coming.
Yes, correct.
Yeah.
Good morning, everyone. I'll be touching upon various aspects with regards to this topic. I also have some comparative analysis done on various other topics with regards to selective capital reduction. I believe in the introduction part from Mr. Atul and Mr. Bala, they have given an overview about it. But what I'll also be covering is selective capital reduction, the whole NCLT process about it, some judicial pronouncement that we generally in our practice regularly use, some landmark judgments, and some important pronouncements that that can help some budding professionals, and also for the people who are starting out new as an advocate or a CS practicing before the NCLT. I'll be discussing the NCLT procedure with regards to the practical aspects of it and not just the rules and the regulations part of it. And whatever challenges that we face in our daily routines, that will be discussed, and somehow if we can help you out with that process, we'll be glad to help. Just start with this slide. Just give me a moment. So basically, reduction of share capital can be regarded as a cancellation of the uncalled capital. I have listed out certain needs and various reasons or rationales behind having this reduction of share capital done. Mainly, it is for eliminating the business losses, returning on the surplus to the shareholders. What I've also not added here is it has also been historically used for squeezing out the minority shareholders through selective capital reduction that we discussed at length in the later part of the PPT. Then there is maybe as a part of the scheme, which in general cases is. So basically, when we talk about reduction of share capital, it is mainly what in common parlance is always used in as a part of a scheme of an arrangement or a compromise or a merger scheme, wherein the company through the merger part, it also adds on to this reduction of share capital as another separate clause in that specific scheme of arrangement. And then accordingly, an approval, a blanket approval from the NCLT is then proceeded with. Then releasing a liability to pay up capital in order to reduce the nominal value of shares, that is to simplify the capital structure, insufficient distributable reserves, and distribution of assets to the shareholders. I've just quoted one of the judicial pronouncement that dictates the share reduction of share capital in ways as to how they can be. The regulatory framework involves Section 66 of the Companies Act, the rules of NCLT. I've also discussed the rules with regards to the company's regulations also. Then Section 61, Section 230, Section 242, and the LODR regulations. But what we'll discuss is at length is the Companies Act provisions and the procedural aspects of it. This is just a reproduction of the original Section 66 which talks about the modes and ways of the reduction of share capital that can be done. The only difference between that is in case if we are transitioning from 1956 Act to 2013, so any of the professionals who are starting out and have been through the 1956 Act and now brushing through the Companies Act 2013. Previously, there was a bit confusion as to when to approach the tribunal, but 2013 Act has specifically made provisions and given out extensive clarifications with regards to when this tribunal's confirmation is required and when can an application be made to the tribunal. Here, I'll just discuss the modes of the reduction of share capital. So here, the Act does not specify the method for capital reduction as such. That regards as to how that can be done. But the tribunal has brought powers to confirm those reductions, provided that all credit either consent or are paid off or their interests are secured. Now, when I say that their consent is taken, is either we now in our common practices we do is we get a consent affidavit or a consent letter. So when we talk about consent affidavit or consent letter, the basic difference here is, I know this is very common knowledge, but for the persons who are starting out new or are very new to the subject, a consent affidavit before the tribunal involves a stamp paper notarized document wherein you take it on a green legal paper and that goes as an affidavit on record. And when we talk about consent letters, that is where on the letterhead of that concerned person is taken on record a signed consent letter, which also works for the tribunal, because it is sometimes on a very practical challenge basis is that when, as Mr. Atul also said, that it gets very difficult to get those consent of the creditors. Now let's suppose a company has millions of, in thousands, the creditors all across India. So to get the consent affidavits and stamp papers to be executed specifically from the state to state basis gets very difficult, not just on the part of the cost, but also with regards to the practicability of the whole process. And to avoid that, what we do is we generally send in a draft to the creditors, send them that they can send this consent on their letterheads and then sign it across, and then we can proceed ahead and file it along with the application before the NCLT. So this is one of the challenges that Mr. Atul very well had clarified. This is what gets a bit challenging when we get the creditors' consent to it. Either which way, if you are not able to get the creditors' consent, it is always a mode available to you to direct NCLT for convening of the board of the meeting of the creditors and get their consents accordingly. Here we discuss the methods of reducing share capital, that is extinguish or reduce the liability on shares. I've just provided a example of it. Now let's suppose if shares have a face value of INR 100 with INR 75 paid up, the company can reduce them to 75 fully paid up shares, relieving the shareholders of the remaining 25 liability. So this is how you change the capital structure, by reducing or extinguishing the liability of the shares. Accordingly, in a second mode is the cancellation of the paid up share capital. Now let's suppose if the fully paid up shares of worth 100 are backed by 75 each, and the company can cancel those shares, that is the INR 25 per shares, aligning the share value with the assets. Then the pay of the excess paid up share capital of fully paid up shares with a face value of 100 can be reduced to 75 by paying back probably 25 per share to the shareholders. So these are just the modes that, through which the reduction of share capital can be executed. Conditions precedent. So now when we say that when you're executing this whole process, there are certain conditions that you need to meet out. Firstly, the company is not allowed to implement the scheme of reduction of share capital if the company is in arrears of any repayment of any deposit accepted by it or interest payable thereon. And the shareholders of the company should approve the reduction by passing a special resolution. And of course, the articles of association should be having that power in execution of this reduction. So basically, now when we say the shareholders approval is required, that is on a later stage after the application has been in place before the NCLT. Now, as Mr. Atul also specified about getting the shareholders approval and the whole process involved. Now, to avoid that, what we do is for a very closely held private company or a closely held company, or where there are a very minimum number of shareholders, what we generally do is we take that consent affidavit route, or we have the consent letters from the shareholders, similarly to what we do with the creditors, so that the whole process is effected in a very timely manner. uh, Now this consent affidavit route might not be very helpful or might not be very practicable in cases where, like for a listed company. Obviously, for a listed entity, NCLT will direct the meeting of the shareholders to be conducted and convened, and accordingly get the approval. But for any other public companies who are not listed, therein, if there are a huge number of shareholders, then we in generally do not address the client or advise them for having this consent affidavit done, because firstly it is very timely process, not practicable, and a huge cost affair for the company. So rather conduct a meeting, and the members present and voting then can accordingly pass a resolution for it.
As you rightly say, in the unlisted public companies, though it is not listed,
Yes, sir.
the number of shareholders would be less. It is possible to practice what you are actually saying. But when it comes to the creditors, the
Absolutely.
creditors base are actually more, then such routes will not be even working there. Because
Absolutely.
there again, we have to send a registered letter and wait for the
Correct.
response, etc. and other thing and all. It's a lot of procedural
Correct.
aspect which is involved, because as you rightly touch upon, much will depends upon the number of people involved. If the
Correct.
smaller number, yes, you can manage. If the larger number, yes, it is difficult. Yeah.
They have been also asking me this query: is that okay if the NCLT approval? I mean, if we get a consent affidavit, and so that is also a major question that even professionals, or for that part clients, have. That is that okay if we give a consent affidavit of the shareholders? So I will clarify that point also to that effect. If we do not convene a meeting, if we do not want to convene a meeting, there the consent affidavits are okay to proceed with, and you can always have the consent letters in place before along with the application. That also works. So just clarifying that point.
Because many times also, as you rightly pointed out initially, anything which is submitted to the NCLT is not got to be in the judicial stamp paper.
Correct.
And not only that, it should be duly notarized.
Right.
That is
Yes.
very important. Yeah.
Absolutely. One exemption that the NCLT is having, and as I distinguished, is when we say that. So now, what general mistakes that people do while litigating is that they write consent affidavits, but they produced consent letters. Therein, then the NCLT then sends them back to get them notarized, or get the stamp paper along with it. So consent letters are also okay, but then when you're drafting the application, when you're making out that application, make sure that you're not mentioning consent affidavits but consent letters. That is just the practical part of it. Now coming to the NCLT procedural part of it, uh, there are rules that are already provided by the NCLT rules, wherein the rule 2 talks about the application form and fees. Now, in a general case wherein you're filing a scheme, or any of the scheme for arrangement or merger, the fees prescribed is 5,000. I mean, I have also got queries from the client professionals for that part. The CAs that engage with me uh, to give them the client a ballpark figure for the whole process involved. So the prescribed schedule fees is of rupees 5,000, and the application goes along with a certain required set of documents that I have also mentioned in the further PPT. Rule 3 talks about the notice and directions by the tribunal. So what I've done is I've at length a step-by-step process for the whole the whole process has been in length and detail has been mentioned in the forthcoming PPT. I'll just come to that. Rule 3 talks about the notice and directions by the tribunal. So within 15 days of the application operation, the tribunal will issue notices to central government, the registrar of companies, Security and Exchange Board of India for listed entities, and the creditors of the company. There also now notices seek representation and objections. Now, in case any of the statutory authorities from that part have any objections to the scheme, or they have any observations, that they send it. I'll just discuss this at length before the steps that have been taken. I've just reproduced the rules here. I'll just come to the step-by-step process of the NCLT. So here, the procedure with regards to the client's perspective and the professional's perspective is that firstly you check the articles of association. This is a very basic thing. I've seen people going back to the clients for checking out if they had the powers. They have sometimes not attached their MOAs, or in the application they have the reproduction of MOA missing. So all these are basic mistakes that the professionals do while starting out. So ensure that the article has the power to reduce the share capital, and if not, amend it and then file this application before the NCLT with the amended articles. Then draft scheme. Basically, when we start out, the first thing that the client requires is a draft scheme. Now, this draft scheme for reduction of share capital can be along with the merger also, wherein you, as the reduction of share capital goes as an added clause to the scheme of merger, or else a separate scheme altogether for the reduction of share capital is carried out. Then conducting the board meeting. Once the draft of the scheme is approved, you call for a board meeting and then carry out the board approval. Holding of the general meeting. Now this is with regards to only after the filing of the application and you get the NCLT directions for it. Filing of the application with NCLT. Firstly, this application goes in form RSC1. Now, RSC1 is after the new amended regulations have come into place. These forms have been notified, and as for the part where people were not aware with the NCLT procedures, NCLT is a pro forma based litigation procedure. This is not something that goes in with a civil or a criminal proceeding where you have petitions at running into hundreds of pages or something of that sort. Here it is a very format pro forma based litigation procedure wherein all the jurisdiction clause or the relief sought or the basis of which the clauses are concerned, they have a pro forma based litigation procedure, and the forms are very very particularly defined, and those are to be filled out. That is how the whole NCLT the application of the drafting works. I've also attached some list of documents to be annexed with the petition. Now, firstly, it comes along with list of creditors that is certified by an auditor. Now, this certified by an auditor, the list of creditors certified by an auditor is something that the NCLT has, very recently, pushed upon. Previously, the companies used to give the list of creditors and the list of directors, the list of shareholders on the company's stamp and the company's signatory basis. But now NCLT has in its procedure added this a very specific requirement from the petitioners to provide a list of creditors, the list of shareholders that is certified by an auditor in specific.
Then it's a question by many clients, but it is not written anywhere, but it is required by NCLT. And Dweep, if you can clarify, is it necessary to be a statutory auditor, or it can be any practicing chartered?
It can be any practicing. So I'll prefer if that is done by the statutory auditor. But I believe if your statutory auditor is a Big Four, or someone who is very much involved in the whole process, I believe they won't be in a very timely or effective manner be able to produce the same. So you can have it done through any of the, I'm so sorry, is the screening stop?
Yeah, screen is.
Yes, screen stop.
I'm so sorry.
Yeah.
Yes. So in case
No, this is not the slide. This attachment you are discussing.
yes, so in case it is not available with you, the statutory auditor, then it is always advisable that any other practicing CA can have it. I'll just get to the slide.
Let me add one more thing.
Yes.
If it is related to listed entity, there is a
Yes.
guideline issued by the SEBI. It has to be certified by the state auditor only.
Yes, absolutely. So for
Yeah,
that,
that is absolutely right. It is in the listed entities, the guidelines is there. Even NSE is very particular.
Very
You have to get
particular,
the
sir, very
certificate
particular.
only from the statutory auditors. I remember initially BSE was a little flexible. Okay, any auditor, but NSE was very particular. No, nothing doing. It is actually the statutory auditor.
Yes, sir.
we've seen some exemptions from it. Now, for recently, what happened is, I don't know if this can be discussed here, but then what we sought was we tried convincing the NCLT for avoiding the stat auditor, because the process is so. I mean, it gets difficult to get in those approvals in a timely manner, and a scheme of reduction or being a scheme of merger, if that not done in a timely process, it does not give you the fruits as to what you intended to be. So we've tried doing that, and at certain instances we've been successful in having that exemptions in place. So I believe it is a very case to case basis. If you have any sort of difficulties, practical difficulties pertaining to it, I believe NCLT has a very broad appetite to uh, consider your point of view. Then what there are some other basic documents that you need to have. It is certified true copies of the MOA, the notice of general meeting, and the explanatory statement, special resolution authorizing the reduction share capital, latest audited balance sheet, minutes of the proceeding at the general meeting where the special resolution is filed. That is a different. Now coming to the NCLT part of it. Now, when we first make an application to the NCLT, it is as in the jargon way, business jargon, a part of it is called the first motion, wherein we seek directions from the NCLT either to exempt us from conducting a meeting, if we have the consent affidavits in place of the shareholders or the creditors, or in case not, then we accordingly have the directions from the NCLT to convene a meeting, to direct us to convene a meeting of the shareholders and the creditors, and accordingly send notices to RD's office, to ROC office, to since it is not a merger scheme. If it is a reduction of share capital that goes along with the merger scheme, then there will be OL's office included, that is the official liquidator's office also, and the concerned income tax department. If there are any sectoral regulators, like if there is a listed entity, obviously SEBI, NSC, or BSE involved. And if there are any sectoral authorities, like if it's a bank, then RBI will be involved. If it's a insurance regulatory, so IRDA. So all those, accordingly, those sectoral authorities are also to be served notice of. I've also got client query that, sir, chalega kya if I don't send it to the sectoral authority, sir, nahi milega, what time jayega? So let's clarify this point, that I know it's difficult. I know it is challenging to do that, but this is what it is. You have to get it. You have no other choices. An NOC is not required from everyone in general. Like income tax at point does not give you an NOC, at in per se. but then that is generally accepted by the NCLT, and they are aware of the whole procedure. So that part, I think I have some stability issues. Just give me a. I'm so sorry. Now, firstly, when this notice comes, now in case there is an exemption granted with regards to convening the meeting of the board or the shareholders or the creditors, then there is no, the publication of the notice or the public advertisement as such is not required, since you're not having any shareholders meeting or the creditors meeting. Therein, you can have so this publication of the advertisement of the notice is required only when the meeting of the shareholders is to be conducted or meeting of the creditors is to be conducted. That can be in one leading English newspaper and one vernacular newspaper, and the same also has to go on the company's website. In case of listed entities, this is a mandatory requirement, since the shareholders and the creditors cannot be traced out so easily. With regards to objections, now when we have this application admitted, the order is passed and the publication of notice is done. Then it goes apart from the creditors meeting or whatever that you conducted, and then once you get an approval, the regulatory authorities, the shareholders, the creditors have a time period of about a month, general cases. But for a listed entity or more, they provide a more particular time period for it. So general cases, we have a 3 months or till there is an approval of the scheme. They have the time to object to the scheme. Once we get this approvals in place, we file for the second motion. Now, in this application stage also, now when this order comes out, along with the notices to be served, there are also various number other compliances that the NCLT directs them to, as to filing of the affidavit of service to the notice that has been sent to the regulatory authorities, the shareholders, the creditors. Then there are multiple other affidavits to be filed by the chairman, for basis that the convening of the meeting has been done in, in the proper manner and everything. So there are certain other compliances that are there itself in the, the order itself. So now coming to the second motion part of it, now once this order is passed, you get in the approvals, you go to the NCLT again as a second motion in the petition stage, wherein you are approving the scheme of the arrangement, wherein the affidavit of service has been in place. You file the ratified scheme that the shareholders or the creditors have approved, and accordingly you seek an approval for the scheme. During this time, what we do is we wait for the representations from the regulatory authorities. In general cases, it is the RD's report, the ROC's NOC, the SEBI's NOC, and the income tax NOC if available. And we wait for a period of about 3 months, and then let the objections be filed. Now, in general cases, I believe Mr. Atul also has been in this process, and he has faced troubles. I mean, we all know that we have the challenges that we face from having this consent taken from the regulatory authorities. In general cases, RD takes up to a month or two to get the reports in place. And that is the case when there are only general observations, general sort of, objections to it, wherein they are seeking some confirmations from your end. The whole process is wherein when they receive this petition for the first time, they ask for a set of documents to that they want for the clarification part, and then they have this report sent across to the NCLT. But now, in case your case is peculiar and a very specific case wherein certain observations are very serious, or there are some investigation proceedings that are pending from your end or from the company part, So all those clarifications, the whole correspondence thing takes a bit of a time. Let's suppose roughly 3 to 4 months. But in case the observations are clear and in general uh, parlance, then the same can be adopted very on a very early stage. Once they file.
When you touch upon the what you call litigation, etc., and other things and all, if the company has got what you call sort of show cause notices issued from the Ministry of Corporate Affairs, which are all still yet to be answered, it is pending in various stages, whatever it is, even involving the directors of the company. There are no objections from the ROC will not come that easily unless until all those show causes notice are all properly answered. At least the company had actually filed a application for compounding the offences filed by them
Correct.
duly in the journal one form and lodged and submitted, received by them, all the matters, then only the NOC will be coming from the ROC.
So
This is one.
very specific to this case is that in case of a reduction of share capital, they may not harp upon it. But this, if being a part of a scheme of merger,
Yeah,
when one company is getting liquidated, I mean, dissolved and, merging into the other one, and that company that is getting dissolved has some investigation proceedings that are pending.
yeah.
Then getting that NOC has been, generally difficult. For that also, we have, procedures in place, because see what happens is that now let's suppose in a scheme of merger, a reduction of share capital is there, an added clause, and that company that is getting dissolved is having certain ROC investigation proceedings or any other offenses that are open to investigate. In general cases before, like 6 months prior, what we used to give an affidavit is that the company that is getting dissolved and the new company is ready to take all the litigational headache
Liabilities.
yeah, litigational headache of the company that is getting dissolved. But now what we recent trend in the NCLT that we have been seeing is the benches are very adamant that until and unless we do not get an ROC report from the same, we are not going to proceed ahead. So previously, and also the law provides for the same, that in case the proceedings are pending, the new company will get in and take the burden of and the headache of the litigation pending for the dissolved company. But now we've seen a trend in the NCLT Mumbai specifically that they are waiting for the ROC report. Now, no matter if it takes 6 months, 8 months, you go to the NCLT, you get a proceeding ahead. I don't care, but I want an ROC report. Is what the stance of NCLT benches are, recent trends. So that is a very difficult or a challenging part for a company who is looking for a merger scheme or for a scheme of arrangement. And if that is not affected in a timely manner, then it gets, the whole rationale behind the whole scheme is wasted. So this is one of the main challenges that the companies are facing.
Yeah, you are right actually, because I'm not aware of this recent trend, what you have said, because this seems to be a latest development. But earlier, which was not the case, you could actually file the scheme
Yes.
and it will be actually heard and everything will be done. But the only thing is, before the approving the scheme, they need to have the NOC from the ROC. Even the notice is issued by the NLC to the ROC to hear their stand. That used to be the case earlier. Yeah. This seems to be a latest development, what you are saying. Yeah.
So
Actually, your views on this, since you handle the listed companies, but in the NCLT's approach.
you're on mute, I believe.
In NCLT, sir, if you have a clarity related to why are you doing the reduction, because judge always asks why are you going for this. So if we have a clarity and we mention everything on our petition and give all the relevant document to the tribunal, so I think there's no further clarity required for the judge to give the NOC and to order to approve the scheme. see, we have all the NOCs, and in my last experience, we have all the NOCs and give the clarity related to why we are going for the reduction, and why, what is the impact on our balance sheet. So they just satisfied and give the order in our favor in two hearing only.
Okay.
That's it, go ahead.
Yeah, please go ahead. God
Yes.
Joshi.
Okay.
Now, when we come to this petition stage, once we get in this statutory approvals, then we wait for this confirmation from the NCLT to have a newspaper advertisement for the final hearing of the scheme. And then once the scheme is heard out and there are no objections filed to it, the same is then passed by the NCLT for an approval order, and the order of the confirmation will be filed in the form RSC 6. Then the whole process, the filing with the ROC and INC 20 and everything will be in place. So this is basically the post compliance of the order being passed. I've just listed out certain regulations under the LODR with response to Regulation 37. I believe there are more, but then I've just, since we are on this subject, I've just highlighted a certain few regulations that are in place. Now, reduction of share capital and scheme of arrangement read together under Companies Act 2013. So, as I discussed, that reduction of share capital for nowadays is a trend wherein it forms a part of the scheme of arrangement rather more than going as a separate scheme, unless it is a requirement of the company for that sort. One just funny instance where the NCLT rejected a scheme of amalgamation on the ground that reduction of share capital required a separate set of procedures to be complied with, for which specific rules had been framed, and hence could not be brought within the confines of Section 230 of the Act. So this is one of the instances where NCLT was of the view that no, you need to have a separate reduction of share capital application or the procedure as set out within the Act, and not under the scheme of arrangement under 230. So this was one peculiar case. Obviously, it had been ruled out by the NCLAT, and I've just shared this just in specific so that in case we get this NCLT view somehow in the future, wherein we have certain funny instances, have been made by the NCLT, wherein the procedural requirements with regards to a particular provision has been, framed some or interpreted in a very vague manner, to be very kind.
God Joshi, I have one question actually to be asked.
Yes.
Because when we read the law, when we go through the things, when we go to the NCLT, we actually get an idea. It is actually nothing but the single window clearance at the NCLT. When it's come to the scheme of arrangement, it may consist many things, including the capital reduction as well. But you don't have to separately comply with those requirements once you go to the NCLT as the form of the scheme of arrangement. That is what we get a simple understanding when we actually go through the things.
Absolutely, sir.
So since you are in the practice, since this particular case has actually come, can it be like this, really speaking?
Absolutely not, sir. Because what you're saying is a single window clearance for a scheme of arrangement. Now, let's suppose I am entering into a scheme of arrangement with any other shareholders or creditors, being reduction of share capital or conversion of preference to equity or whatever of the sorts, or even for that part a name change application for a merger scheme. So all these form part as a single window clearance for the NCLT to be approved if the RD or the ROC is okay with it. I feel I mean, on a very lighter note, is that the NCLT intervention for something like a reduction of share capital, which is totally the company's business to deal with. I believe these are certain business point of view decisions that a company requires at a certain point in time. And NCLT intervention at that point does not, in a way serve better or serve effective to the whole transaction. Rather, have it before the RD or the ROC to have an objection to it or any other clarifications required. Once we get the NCLT into it, the problem is the litigation aspect of it. I know I'm kicking my career in this. I mean kicking my part of the portfolio career in it. But then, in the larger scheme of things, I feel that the NCLT intervention for a very specific business transaction, for a merger scheme, or reduction of share capital or things like that, for those things, I feel on a very personal note that any sort of court intervention will only delay the whole process, rather have a timely or effective transaction to it. Rather have some statutory approvals be required from SEBI, from RD's office, from ROC office. So those statutory authorities can intervene, but a court intervention at that point in time delays the process, rather effectively execute the whole process.
I think
Is
the
what
process is like initiation of step is fast track merger.
Correct.
Yeah. So I think they have also started thinking, but it will take time because even many times we also see
I
the
feel
so
NCLT and the current jurisdiction is, I mean, the current judiciary is so overwhelmed in the existing IBC cases coming in huge lots. And to manage the whole thing is getting difficult and, above the appetite of what the current benches can, kindly execute about it. So I feel the court intervention for any specific business transactions is not advisable. In fact, for that point, the as we discussed yesterday also, Bala, so that UK, US, and the other courts outside India's jurisdiction do not involve the court intervention for such processes, and the whole approval process is easier and a very timely, effective manner.
In fact, I also dealt with the NCLT in one of the companies' case. We handled the larger issue of the merger and amalgamation. Around 12 companies have got merged in one single company. Here, what has happened is in the different company, the capital structure of the company was so different. In some of the companies, preference shares were there. Each value of the share itself is 1 lakh rupees of the flash value. When everything is merger is actually formulated in some of the companies, in place of the preference share, there was a conversion of the preference share into the equity share. In some of the companies, in lieu of the preference share, issue of the equity shares. All those questions were actually there. But when the company went for these things, as you rightly say, it's a single window clearance. But the only thing is, the NCLT has raised certain clarifications. That means especially the valuation part of it, how it is actually justifiable. You are actually having a 1 lakh worth of preference share capital, but you are issuing the equity share capital of 100 each is so much. How the valuation is actually justified? That was the one query which has been asked. Some of this company had obtained the valuation certificate. You may be knowing that one of the valuer was a Rothschild, who are very renowned valuers from where they have actually obtained it. And not only that, by the time we submitted the valuation report, the scheme has taken almost about 3.5 years. So because of that, to safeguard the interest, we have again obtained the valuation certificate within the 6 months period of the time before the scheme was actually approved. So the company was able to justify that, give the clarification to the court to the satisfaction. Yes, the valuation what is earned by the company is justified because court has a reason to believe, as you rightly say, there is no undue use of the scheme is actually being made. That only they want to ensure. But complying separately, going through, it is not permitted and all the things is really unheard of it. Because I have seen this scheme, this particular scheme has, although we thought initially the scheme will get over by 1 year, 1.5 years maximum. Ultimately, by the time we got the approval, it is 3.5 years time we got the approval. Because there are other sectoral.
This is a major concern that the clients firstly in the first interaction they do not care about the cost. The whole thing is about the time consumed. So I, as an advocate for the first part, I simply state that I cannot guarantee you with anything. Now, as per books or as per the academic things that have been placed upon, they say about 6 months, 9 months. But I purely say that 1-1.5 साल तो आप पकड़ के ही चलना, फिर अगर वो NCLT की इच्छा हुई and if we are in a good favor or good luck with that part, then we can get it done before that 1 year, but आप पकड़ के चलो उतना time. So that is what the whole intervention part, consequences of court intervention in this for business transactions like this should not be involving a court intervention or tribunal intervention. And which was coming to this slide, this is also one of the major feedbacks or queries that I get is, or how is it different from alteration of share capital and the reduction of share capital. So I've just created one of the slides wherein uh, defining as to how alteration of share capital can be different from reduction of share capital. I have also have a table format for the same, wherein I have given basic differences, wherein the major difference here is the alteration of share capital does not involve an NCLT process, obviously, and the reduction of share capital does. And there is a special resolution required, there's an ordinary resolution required. The change in the name of the company with the term add and reduce is required, and obviously it is a lengthier process. Here the creditors are not affected, here the creditors are affected. So basically it's the general difference between the two.
So in a simple language, alteration is a change in the authorized capital.
Yes.
Reduction is change in the issued capital. Issued means the company already received money, so it's dealing with cash, so everything will be compact.
Correct. I've also provided certain ways wherein the consolidation, the converting of the all paid up shares. So coming to selective capital reduction now, this uh, is what I was touching upon, is that selective capital reduction, this is one of the major ways that historically has been used for squeezing out the minority shareholders. Now I've recently come across one of the clients wherein a minority squeeze out was that they were looking at, and there was a desperate need for them to squeeze out the minority shareholders. The company is a wholly, they hold about 99.9% of the company, and there are about 10 or 12 employees that are not ready to come out of the company, and they were very adamant on the part that we want to stay, and company in fact had provided them with an offer for more than twice the amount of what the valuation was, but still are very adamant on not squeezing out. So eventually they referred us, and then they asked what are the ways. So one of the ways that I suggested was selective capital reduction also. And now since the Companies Act has notified in 2020 the provisions for 230 subsection 11, wherein the company taking over has specifically can file a scheme with the NCLT for squeezing out the minority shareholders. So that is another way of wherein the minority can be squeezed out, and the only part where the court intervention would be to the part that a fair valuation price has been given to the shareholders uh, that are exiting, and their interests are not affected in any other way. So capital reduction in general refers to process of decreasing a company's share capital. This is specific to a certain group of shareholders and not in general to all the shareholders. This is the major difference between the capital reduction and selective capital reduction. This can be done either by cancelling the unissued shares or by reducing the paid up share capital of the company, and it is aimed at adjusting the capital structure to reflect the current needs and the financial status of the company. Also, just to add to it, as I said, by squeezing out the minority shareholders. What I'll just for the ones who are asking as to who's, have this query as to why this squeezing of the minority shareholders was important is, now let's suppose take an instance for a public unlisted company. uh, I mean, now let's suppose a company is holding 99.9% in a public unlisted company, and that company, until it's a wholly owned subsidiary, has to follow the guidelines for appointing of the independent directors and everything. So all those compliances are an added burden or an admin cost that they don't want to incur. And for the past 5 years, they've been incurring, for an instance, what I shared. So those are the instances where the squeezing of those minority shareholders gets very important. And for that, these are the purposes and the objectives to it. Uh, it provides an exit to the specific shareholders, reorganize the shareholding pattern, settle disputes with the minority shareholders, align ownership with the strategic objectives. This is basically a tabular difference between capital reduction and selective capital reduction. The regulatory scrutiny under capital reduction is, a procedural compliance, but in selective capital reduction, the regulatory scrutiny is much higher because the regulatory authorities are more, inquisitive about as to why are you doing this. A certain shareholder has been, a group of shareholder has been, selected to be squeezed out. So why is that? Are you trying to defraud the whole process or the shareholders, specific shareholders? Uh, Historically, and while I'll just come to the judicial pronouncements also. The impact for capital reduction is uniform across all shareholders, where everything has been pari passu to all the shareholders, and this is specific to the targeted shareholders. Objective is general financial structuring, and this is for strategic shareholder realignment or dispute resolution with the minority shareholders. In capital reduction, the standard creditor consent or security provision is present, wherein you're similar but with potential higher scrutiny because obviously the NCLT is more inquisitive and more engaging with the litigants that why are you seeking such a process or such a scheme. Here, the special resolution and the NCLT approval is required. Your a special resolution detailed disclosures as to why the scheme has been allotted, the detailed process and the plans of the company for the future also. So what happens is generally the NCLT is only involved when with regards to fair valuation that has been provided to the shareholders that are exiting. And secondly, if there is any upcoming projects wherein there is a huge money or concentration coming into the company, and the company decides to, somehow do not give it to those specific set of shareholders. So that is where the NCLT or the regulatory authorities are very specific with, and they have gone to an extent to seek an affidavit from the company or the promoter, directors, or the shareholders or the directors that there are no projects upcoming that that out directly or outs the specific set of shareholders from that consideration only. So they've gone to that extent also in certain cases. But then obviously they have not intervened with regards to any normal business course of it. And they have only to the extent that the valuation price and the exit price that are given to the exiting shareholders is fair and just. Judicial view on selective capital reduction. This is one of the case wherein the principles were, enumerated. Is reduction a private concern of the company, and if the majority has voted for reduction, then they also have the power to choose how such reduction is to be carried out. That is in any manner. Now, basically, wherein the majority shareholders are running the company. Now, let's suppose I am holding a 91% shareholder of a company. I am 91% of shareholder of the company. I get to decide at least how to deal with that company. If now, as an instance that I shared, now if that company holds 99.9% of the shareholder of the company, and there are 10 to 12 ex-employees of the company holding those shares. So now it is purely commercial or a business wisdom of that shareholder to conduct as to how they want to go ahead with it, not rather than comply with the provisions of having an independent director in places, increasing their admin cost. You have to enjoy the benefit of being a wholly owned subsidiary. So these are the points of the valuations from a very commercial point of view that the shareholder wants to enjoy. And that is why here even the high court or even the courts have recognized the need for the same, and here they have allowed such a selective reduction and considered it as a very domestic matter of the company. The court only to check if the said reduction is fair and equitable. Here, the central government explicitly introduced the provision for squeezing out by making certain provisions for the Companies Act to be effective, one of which was Section 236. I mean, squeezing out the minority shareholders, and that can be a very separate subject altogether, as to because the Companies Act provides various weighs and articulates to have this minority shareholding to be dealt with. This is one of also the interesting cases that we regularly refer before the NCLT and the other tribunals wherever applicable. This is Brilio Technologies versus Registrar of Companies. This was before the NCLAT. Now I have tried to somehow put it in a very concise manner where the key issues were discussed. I mean, these court order runs into pages, and to somehow sum it up in a PPT slide is very difficult. But I have somehow tried to concise in a very concise form. So I'll just read out those views. Key issues that were not considered by the NCLT and upheld by the NCLAT on selective reduction is NCLT held that it dismissed the petition stating that selective reduction of share capital was not permissible under Section 66, suggesting it might be covered under Sections 232 to 32 instead. That is what I previously said, that Section 66 provides for this selective capital reduction, and it not might be only covered with 230 to 32 provisions. NCLT held that selective reduction of share capital is permissible under Section 66, provided it is just, equitable, and follows the legal framework. The tribunal referenced precedents to support that selective reduction is a valid practice. So I have had certain experiences where the client were कि सर हमारा तो हमने तो ये पढ़ा हुआ है कि शेयर होल्डर्स को आप निकाल नहीं सकते हो in the Indian law, but there are certain exceptions to it, and if done in a very in the boundaries and within the boundaries of the legal framework, the same can be carried out.
The main thing is that it is not harsh to the shareholder. They
Correct.
should be beneficiary.
Correct.
And there is a larger interest of the
Absolutely.
company and the business.
Absolutely.
So
Absolutely.
against the larger interest of the business and well-being of the company, it cannot be considered the few shareholders' interest should be prime importance, because that interest should be financial, and if that financial interest is protected, it should be permitted in the larger interest of the company. This way we can put it in such a situation, this selective reduction of share capital is possible. You should be able to convince and explain the regulatory and especially judiciary the same situation.
Absolutely. They also touched upon the use of the securities premium account. If I don't know if it helps any of the CAs that have joined this webinar, the NCLT ruled that the securities premium account could not be used to pay non-promoter shareholders, as it was one of the purposes listed under Section 52 of the Act. However, NCLT allowed the use of SPA for paying non-promoter shareholders, referencing judgments from various high courts that supported the utilization of share premium account for which purposes beyond the specified uses in. So this is one of the landmark judgments, madam, that CA have been, referencing to in the NCLT. Creditor's consent, the NCLT noted that the absence of creditor consent affidavits and used this as a ground for dismissing the petition. NCLT found that the obtaining consent affidavits was not mandatory as long as notices were duly served. So I'll just come upon this also. Now, what has happened is that in case there is nothing apart in the scheme of the whole arrangement that affects any of the creditors. So what we do is we generally have this exemption granted from NCLT, that we rather only serve notices to the creditors and not take their consent, because it gets in place of difficulty on behalf of the company, as I discussed earlier, that we have gone ahead and seek exemptions from NCLT, wherein we know that the creditors are not affected in the scheme of arrangement, and I do not need to serve them or get their consent in place. So we've relied on a number of judgments for that, and we've done that in the previous my previous outings also with NCLT. So therein we, as Mr. Atul also was saying, that getting that creditor's consent is very difficult, because ऐसा होता है कि चाय वाले को भी भेजना पड़ेगा, because the creditors involve secured as well as the unsecured creditors. Now, if I get upon unsecured creditors, I have a list from vendors, from stationery vendors to tea vendors from the company. So company वाला बोला सर उनको भी भेजना पड़ेगा क्या? मैंने बोला भेजना तो पड़ेगा, but what we do is generally we have a certain benchmark in place. Now what we seek directions from the NCLT is in a way that we filter out on the basis that sir हम क्या करेंगे, हम serve सबको करेंगे, but हो सकता है हम consent सिर्फ उनका ले जिनका amount is beyond 1 lakh, so that we can filter out those at least vendors from the and the admin cost and the admin process gets a bit easier on the part of the company. So that we have been suggesting. We have also served to that part also, that हम service भी नहीं करेंगे उनको, because we know in the end they're not going to be coming to you, and your amount of creditors is huge. So that way we can somehow convince the NCLT to reduce that part for the company's point of view, that administration procedure and the cost. So that we have done, and we've been successful.
Basically, to show the financial capability of the company with
Absolutely.
the members and the creditors, it's we can say it's so huge, small amount. It doesn't risk anything to the creditor, as the
Correct.
company is so financially sound. If that is proved, then the judiciary do agree.
Yes, absolutely. It also highlighted upon the untraceable shareholders. The NCLT did not adequately address the handling of untraceable shareholders and the related procedural compliance. So NCLT upheld that the company must hold the amount payable to untraceable in an escrow account for 3 years. That is basically the IPF provision, and this approach was deemed compliant with the statutory. So this also, madam, we have come across from the clients that सर हमारे शेयर होल्डर्स है जो ट्रेसेबल नहीं है, उनका एड्रेस अपडेटेड नहीं है, उनका ईमेल आईडी इज नॉट विद मी, या ऐसा कुछ होगा तो सर हम क्या करेंगे? इन दैट सिनेरियो दिस इज what the provision expressly says, and even has been upheld by the NCLT and the other benches. So conclusion, the NCLT set aside the previous order by the NCLT Bengaluru confirming the special resolution passed by Brilio Technologies for the reduction of share capital. The company was directed to register the reduction and publish the notice in specified newspapers, ensuring compliance with the statutory requirements. So implications of this was that it clarifies the legal framework for selective capital reduction was permissible, and use of securities premium. That was a major, major outbringing of this judgment.
Very important judgment, because in chat box also there are 3-4 questions which all are answered in this judgment.
Correct. Correct.
Not only that, this particular judgment, I think Jawab Joshi will agree, is frequently referred by the judiciary while delivering the judgment. If we go through the various orders, this judgment is actually quoted by many of the judiciary as a precedent.
Correct. Correct. In the similar lines, one of the landmark judgments of Sterlite Industries. I mean, I believe the practicing professionals have obviously come across it, but for those who have somehow not been able to come across, just a very brief, concise form of those judgment has been reproduced. I have tried my best to accommodate everything, but then as I told you, the orders run into pages, so I've tried my best here. Here the scheme of the background is the scheme of arrangement was presented under Section 395 of the 1956 Act. It aimed to buy back this amount, X amount of equity shares, approximately 50% of the issued capital. It was approved by 95.69% in number and 91.26% in value, and unanimously by secured and the unsecured creditors. The key legal issues and the arguments were that on the maintainability of appeals. So SEBI's appeal was that they argued that it had a statutory right to appeal due to its regulatory authority under the SEBI Act and Companies Act. The court's decision was that the Companies Act does not provide SEBI with the right to appeal or require notice to SEBI in proceeding under 391 or 94. SEBI's locus standi to appeal was denied. So basically here what had happened is SEBI had intervened after the order had been filed. Now, this is a very common thing that we've seen. I believe we have a matter wherein, ma'am, you would be very, this is that while dissolution applications, when we will file dissolution application and income tax have them vacant after 8 months or so, and then they say, nahi, hamara iska itna due baki hai. So that is similar to this situation wherein SEBI had claimed its statutory right to appeal, wherein the order was already passed by the lower court, by the company law board. So therein the court had decisions stated that it had not had the right to appeal, but rather when the court notice was served, they had the right to only object to the scheme or have any observations to this.
they can represent what is the issues they face, what is the concern they will have, and what effect it will affect to the interest of the shareholder, adverse interest, so that accordingly court can guide the applicant to, if require, necessary clarification or changes in the scheme, but not that way straightway stop it as such. Yeah.
The central government's appeal was that the central government contended it had a duty to protect the public interest and was entitled to appeal under Section 394A, which requires the notice to the central government. Here, the central government's appeal was maintainable due to its statutory role in safeguarding the public interest and ensuring compliance with corporate laws. Here, the court's power to sanction the scheme. Now, the appellant's argument was contended that the buyback should adhere strictly to Section 77A of the Companies Act. I believe yesterday, Bala sir, we had a discussion on buyback and the difference of reduction of share capital. So here also the company, the act, this judgment has touched upon those bases also, that for a buyback there is a the whole procedure in place under Section 77A. That was the previous act. So there is a clear distinction provided between the reduction of share capital and the buyback, wherein buyback can be done at the company's end through by the board resolution and the special resolution, wherein the court's intervention is not required. Here the specific, the court's decision here was that Section 77A was designed to provide an additional, a more straightforward method for buybacks, not to supplant the existing provision under Section 100. So this, what the appellant's argument was, that the buyback should adhere strictly to 77A of the Companies Act, introduced by the companies. It claimed that the scheme under 391 was improper because Section 77A, being a special provision with non-obstante clause, overrides the general clauses of the provision. So here we get that clarification that even though buyback provisions are available, a capital reduction scheme is totally a different procedural aspect, wherein the court's intervention with regards to creditors is also interest is protected, shareholders' interest is also protected, and buyback provision is a company's affair, wherein the court intervention is not required. The amount of buyback that is involved, there also we have a 10% a limitation, 25% limitation through special resolution. So all that procedure is in place. So the court retained its jurisdiction to sanction schemes under 391 and 104. And the presence of Section 77A did not eliminate this power. And the non-obstante clause in 77A does not imply the exclusion of court's jurisdiction under the section, but offers an alternative method for buyback without the court involvement. So here, everyone, I believe there were a few questions in the chat box wherein they were referring to buyback and reduction of share capital. So I believe that has been answered here. In case not, we'll obviously deal with it later. Then on the fairness and the legality of the scheme, the appellant's concern was that argued that the scheme was unfair as it treated shareholders' silence as consent, potentially violating Section 108 of the Companies Act regarding transfer of shares, claimed insufficient disclosure of material facts to shareholders, and procedural lapses such as suspension of trading without proper authorization. So here the court finding was that the scheme's substantial implementation, the lack of prior objection by CD, meant it was inequitable to invalidate it post the implementation. It recognized that while treating silence as consent was unconventional, the overwhelming approval by the shareholders and creditors indicated substantial acceptance of the scheme. So again, here the majority shareholders have been highlighted. The majority's view is highlighted. And it found that no significant procedural violations that warranted setting aside the scheme. The court noted that the procedural lapses, if any, were minor and did not affect the overall fairness and the legality of the scheme. So all these aspects of the decision helped personally a lot to me, wherein I present before the court. There are a number of instances where the client has told me, sir, इतना ही approval मिल सकता है, इतने ही creditors हो सकते हैं, हमको इतना ही shareholders का approval मिलेगा, इतना चलेगा क्या? On a safer note, I always say 95% हो जाए तो अच्छा है, नहीं होता है तो we can try out something. So these judicial pronouncements somehow help us, and I believe it can help other budding professionals also. So here the conclusion was the appeals by SEBI and the central government were dismissed and the scheme sanctioned by the company court was upheld. Now the legal implication that companies could pursue buybacks either through court sanctioned schemes or via the procedure. So this is mainly wherein it highlighted that these two are separate procedures and they do not intervene with each other, or the court intervention is not required in that buyback part of it. Yes. So now coming to the valuation aspects of it, I'll be just giving you a very brief form of it. NCLT is not interested in as to how the valuation is being carried out. What they only rely upon is whether the valuer appointed is a registered valuer, knows what he's doing basically, and the he what NCLT is concerned is whether the fair valuation has been carried out by it or not. Nothing apart from that is NCLT concerned about, or any other tribunal for the court for that matter. So under the Companies Act, no scheme can be sanctioned unless the auditor certificate is filed with the NCLT stating that the accounting treatment, if any, proposed in the scheme is in conformity with the accounting standards prescribed under 133. The valuation of shares is of paramount importance in the process of successful reduction of capital. Indian courts have always refrained from taking a deeper dive into the domain of valuation, and the same has been reflected in their view through their decisions. So I'll just present certain judicial pronouncements that have been done. In case of Cadbury, the court had held this principle that it is not possible for a court to go into the exercise of carrying out a valuation itself. That, as the Supreme Court said in the Mihir Mafatlal case, is not court's remit. Courts do not have the expertise, the time, or the means to do this. I do not believe that they are expected to do it. What the court's approach must be to examine whether or not a valuation report is demonstrated to be so unjust, so unreasonable, and so unfair that it could result only and manifest and demonstrate inequity or injustice. So as I said, the court is not interested in as to how the valuation has been done, what it is done. It totally relies on the auditor certificate for that part. And if there is anything that the shareholders or the creditors are of concern with, nothing apart from it is the NCLT or any other court interested in. Now, the impact of recent judicial decisions between Devinder Parekh Kalra versus Syngenta India Limited was the scheme was approved by NCLT in 2020. Appeal and judicial intervention by minority shareholders appeal was that it contended for a fresh valuation due to significant financial improvement. Now, what had happened is when the scheme was filed, it was probably around 2016. And as we see in our daily routines, we've seen delays happening for over years in the NCLT and the other proceedings. So what happens is when the company's scheme was filed and when the company's current status is compared, the amount of growth or the amount of losses that the company may occur is huge. So for this instance,
there was I think net issue earlier. Can you repeat?
Yes. So as I was saying, in this matter, there was a fresh valuation appealed by the minority shareholders. So what had happened is the scheme was filed in 2016, and by the time it got approved by the NCLT, it was 2020. So this is a daily routine for us, wherein we know that these kind of delays happen, and the company's financial from the date of filing of that scheme and the day that it gets approved is transitory very huge as compared to what the at the date of application was. So your NCLT directed that a new valuation based on the most recent financial statements could be done, and Supreme Court also upheld a directive for a fresh valuation, emphasized the right of shareholders to expect the latest and fair value of the shares. So on a company's perspective or the client's perspective, I'll just say that now when such a thing happened, now we have witnessed this also. Now there was one company that had filed its application in 2020. when it got into the scheme filing and the process taken by the NCLT, now it is 2023 or 2024, and the company's financials have changed significantly. So we have had instances where the NCLT has told us to get a fresh valuation in place, wherein they have told us that the company's scheme filing, and now even NCLT is aware that it is not something the mistake of the client or the mistake of the bench. It is the litigational aspect of it. And since that is in place, now it should not affect the shareholders in the way that they get a very less price for what the current status of the company is. So in this kind of scenarios, it gets very difficult. And now we can see the desperation from the end of Syngenta Limited also. They went to NCLT, they went to Supreme Court, they went through all of the litigation aspects so that they do not get into fresh valuations. Because what happens is once you get into fresh valuations, the whole dynamics of the scheme change. There is a fresh scheme to be filed by the company. The whole process is like starting from the scratch. So that the company wants to avoid. Now they want that this scheme was filed for the effectiveness in a way that it helps the company, but rather it has devalued the company, and it has got into a process where loss is imminent. So this is one of the cases where litigation hampers the whole situation. So as we discussed before, the court intervention for I feel for such matters is very difficult to manage with. I have highlighted some key highlights from FEMA regulations also. Have a very limited time for it to touch upon all those bases, and since we are handling only a masterclass based on the Companies Act, so I would rather not touch upon those aspects. So I have tried to have valuation done from the valuation aspect, the litigation aspect, the procedural aspect of it. And now I believe it's Ms. Harshada that has to take over for the
I think,
taxation.
before that, we will collect all the questions.
Yeah, we will take the questions before that, one thing.
Yeah, Harshada, 1 minute, we'll answer the questions because they are waiting. Yeah.
And one more thing, I would like to ask one thing for my information, even for the other people information, Dr. Joshi. The whole process, although we talked about the time frame, generally, in your opinion, what is the approximate time frame, the range of time frame? Means, what could be the minimum, what is the maximum that could happen? Suppose if we go for the scheme, okay, because when we work out, what the best thing can happen, what the worst thing can happen. So in your opinion, what is the minimum that can happen? What is the maximum that can happen?
Let's put it that way. This is the burning question of the hour for clients also, for me also, because even I am clueless after the point. Because see, it has surely improved after the COVID period. 2020 to 2022, those 2 years were very difficult to manage with, and that has led to what it is in right now. Because during that process, the amount of applications filed with the NCLT were huge, and the time that they got to deal with those applications were very less. So that is why the whole backlog has been created. But now, since it has improved a lot, and I'll say that I, for a very safer side, assume it to, let's suppose, keep it 6 to 9 months or 9 to 12 months for any scheme. Be it, I know reduction might take a very less time for it, maybe 6 months. But as a litigator, as an advocate for that company, I would not give them a very false hope where I cannot assure them. What happens is there are a number of things involved. There are like now there is a certain point where a bench is going to be changed. या उनका कुछ reorganization हो जाएगा, or the assignments have been changed. It has been transferred to another court. So all these are very, very peculiar things that happen, and we cannot guarantee of that part. But for a very general thing, without any statutory cautions to be placed in, I would rather say 6 to 9 months or 9 to 12 months at an extent wherein you feel. Now let's suppose there is a scheme of merger which involves multiple companies. Well, as Balasa told me yesterday, that they had a company wherein 12 companies used to be could have been merged into one. So for those entities, I would rather still say, chalo 9 to 12 months pakad lo. And for a general thing without any cautions to be, in place, I would rather say 6 to 9 months or 9 to 12 months is what the extent that I would.
Because the reason why I asked the question is that the merger in which we were involved, actually, it took almost 3.5 years to get
Almost.
the final approval.
Absolutely, sir. I totally agree to it. And what happens is there are multiple things related to it. So what a client does not understand at that point in time is that this is not something that we are happy to do with कि हमको इसमें कुछ हमको now what they think is ये लोग per hearing ले रहे हैं इनको पैसा देना चाहिए. I would rather say ऐसा कुछ नहीं. It is only point is that it is not up to us. It is certain implications from the bench itself that hamper the whole process. And that is why I just discussed court intervention for such processes is very difficult to manage with.
Because what has happened in the case where we were handling it, there are 2-3 regulators were involved. The telecom approving authority for the sectoral gap, which was actually going up, there was one of the authority which was involved, who's sitting at Delhi. The scheme was actually being held in NCLT and Bombay. There was really a thing, you first get their approval before we give the approval for the scheme. No, you get the scheme approved so that only we know it is increased. We will give the approval later.
Correct.
So question came between the two regulatory authorities. Who will have to give the approval first? That has become a very big issue in our case, which has taken almost about 6 to 8 months to sort out that time limit.
Correct.
So that is where I asked this question, because this is the.
So ultimately, who was first?
Ultimately, NCLT forced us to get the approval from the telecom authorities.
So you get regulatory authority first.
Yeah, we went to the regulatory authority. We have to convince them. We have filed the scheme.
For anyone facing the same problem, I would suggest get an NCLT order specifically or directing that regulatory authority to act in place. So क्या होता है sir? Now if we go and say it, no, they don't listen to us. So rather mention it before the NCLT, get a directional order from them, and then get it done. वो तुरंत हो जाएगा.
No, here what has happened, because NCLT when it was given, the company has actually given what is going to be the pattern between before and after. The sectoral gap has already gone up. When the sectoral has already gone up, NCLT has raised the question. When the sectoral gap is going up, do you have the authority approval for this? You first get the approval. That is what it has happened. So when we approach the sectoral authorities, they told the scheme is not approved as on today. Sectoral gap is not gone up. Once the scheme is approved, then only it is going to go up. So first to get the approval. That is what it has happened. Between we were standard between this and that ultimately we went to the telecom authorities. We told very clearly the scheme is already in place. The first meeting has taken place. The second meeting in place is the verge of approval. They are on the no objection certificate is being waited, etc. Once it has happened, then this definitely is going to go. So you say that upon the approval of the scheme, the sectoral gap is going up, you give the authorities. That sort of thing we put forward. Ultimately, as you rightly said, they insisted for the certification from the statutory auditor there too. Correct. And the instructions were actually statutory auditor, not from any other auditor. And unfortunately, this company have one of the big four of the statutory auditor. You know how the big four works.
Absolutely.
Not only in terms of the time.
In fact, one of the questions in the chat box is, why is it that a big four is not going to give?
No, it is not only that. Before big four is giving, they want to have n number of documents, their checklist, etc. and other things. That is one. Second thing is you come to the cost part of it, that's another issue.
Correct.
So anyway, all said and done, we were to get it done. So finally, we got the approval from the sectoral authorities and produced the NCLT. Thereafter, only the order has been passed.
Yeah, judiciary is also right, because sectoral authority knows the nitty-gritty of the industry, and if they approve, whether this consequential impact within the parameter of their sectoral regulation, that they want confirmation. Because once their order is given, it is effective and it's final. So they are very much right that regulatory authority, sectoral regulatory give approval. And as regards timeline, we have to be very, conservative as regards the time taken. And we have to keep in mind contingency, because so many regulatory authority and stakeholders are involved. Your creditors are involved, your shareholders are involved, your 3-4 regulatory involved, and then come judiciary. It's a very long procedural driven entire work is there. So that's why we have to keep in mind that it is going to be a very delicate issue anytime. So we have to be kept in mind that we have buffer for the timing. Yeah, good. Please.
Can we have questions, ma'am?
Yeah.
Yeah, sure.
First is, I believe, from Paresh Bagrecha.
Let us get into
it
the questions
necessary-
here. We will
Is
start
it
from the
necessary
beginning.
for all companies to obtain approval of creditors for buyback of shares? So, yes, I have discussed this earlier that as the provisions expressly mention that if it goes, I believe, Bala sir, just correct me if I'm wrong.
I think you have answered. Even
Yes.
the second question, what is the difference reduction buyback? You have answered.
Yeah. Reduction of buyback is already
Whether
answered when you have put a
conversion
chat.
of equity. Yeah, this is interesting. You can.
Yeah.
Whether
The conversion of the equity into preference should amount to the reduction of capital.
Correct. I
Sir,
believe.
let me
Yeah,
handle
Mr.
this.
Atul.
Yes.
Yeah, please.
We can say it will be noted that both equity and preference share capital appears in the balance sheet under share capital, right? And under the act, like section 43 said, there are two type of equity share capital. So both represent a share capital and both appear in the capital clause of the memorandum with the appropriate description described to distinguish them to two class of shares. When shares of one class are converted to another class and the value of paid up share capital does not undergo any change, the subscribed and paid up capital remains unchanged and only nomenclature of shares undergo change. Hence, it could be said that there is no instance of capital reduction, ma'am.
But I will put up the question to the taxation and authorities. I'll ask her actually. She is going to
Right.
answer. Because now if you look at it in days, the preference share capital is actually regarded as their long-term borrowings.
I was coming to that also.
Yeah, because when it is a
It's
long-term,
very complex thing.
yeah,
And actually governed by the issue and all that, whether equity is a own capital and
Yes.
preference shares has a compulsory redeemable preference shares, and that's why he specially asked this question.
That is right.
But
Absolutely,
then-
you are right. Because
Then you are compulsorily bound to repay. But my dear, again, here you have to go to NCLT if you can't redeem and all that. So it's a very complex thing before, and it requires research. Whether equity can be converted into preference, we will not able to answer this immediately.
Dipti, as I was telling you in the 12 companies merger into one company, in one of the company, they had the preference share capital. But what had happened when we filed the scheme, it was actually on the 18th year of the preference share capital, which was there. But by the time scheme was delayed, the 20 years period has already lost.
Correct.
The NCLT said you cannot have the preference share running beyond 20 years. You repay the preference capital. That issue has actually come out. Whereas the scheme was actually saying, in lieu of the preference share, equity share will be allotted to other companies. That was another issue what we have actually faced. It has again taken, a hell of a lot of time to convince authorities. Ultimately, the approval has been given in that. So that
Yeah,
was the
but
situation.
here what is happening, Mr. Bala, that instead of preference,
Yeah.
which is temp period, earlier it was allowed that you give the shares and all that, then equity.
Yeah.
Here what is happening, equity, which is a perpetual capital,
Yeah.
is converting into temp capital. From own capital, even the preference share is a share capital, but please note that it is payable. We have discussed in the preference shares.
Yeah, that is right.
That is the point that we have to keep in mind. That's how you are doing, that you are planning to, because again, what is the terms of preferences? You can say repayable at any time. So you are repaying equity capital without doing reduction or buyback by converting into preference shares, which can be payable or redeemable at the option of the company anytime. So that is the point. This way you cannot do circumvent. So this is not possible according to me. However, Mr. Atul, Dweep and Mr. Bala, you can give your point.
No, probably I'm not very
It
sure
depends
because
on entire circumstances. It can't be in one line this answer.
Yeah, that is one thing. And the second thing is that since we are all talking, what you cannot do in the routine course in the company side, you can get it done through the scheme of amalgamation through a single window clearance by the NCLT. Means that is there. Probably it is a question of, drafting the scheme and presenting it in such a way which will be justifiable, getting the thing. If the NCLT could actually get justified, give the approval, then something could happen. That's what I would presume actually.
Correct. So
And
summarizing it,
you have to give some logic and reason. Just I want to convert equity into preference, it will not happen.
Yeah, that is it. That is the point.
summarizing it, as Bala sir said that putting into a scheme of arrangement and putting it across NCLT, having some rationale behind it, having justified business point of view behind it, then the same can be still, under the single window clearance can be approved of, but not otherwise.
I said the people, especially the company secretaries who are in the practice in NCLT, they need to have the larger application mind and the drafting skill of forming this scheme of arrangement. That's what I say.
Yeah, no, application of mind is there, but the thing that always we have to keep in mind that.
No. What you have application of mind is okay, but how to transfer the scheme of arrangement and putting it in the, scheme. That means, drafting the scheme. The drafting skill I am coming to.
Yeah. We need to work on in a proper way that it serves the purpose of the ultimate industry and shareholders.
Okay.
And it does not adversely affect creditors or other stakeholders. We have to keep in mind, otherwise it will not be approved.
Company was incorporated with a paid up capital of 50 lakh rupees. But now the promoters decided to wind up and do not want continue. Can they go for the reduction of the capital so that ideal fund lying in the company can be paid back to the shareholders to some extent? Then they can follow the winding up process.
I'll just take this. If the whole process is done only so that the capital can be, or the funds lying can be distributed, I feel then the winding up process serves the same, because now in case you're winding up in the end and all the creditors are being paid off, then the whole funds lying with you that are idle in the situation can eventually be distributed amongst the shareholders or whatever the extent.
And I think in both the cases, till the capital is there, it will be capital, and balance portion will be
Will
divided.
be for the creditors. Correct. Will be for the creditors.
It is same thing it will be.
Correct.
Why would the NCLT need the consent letter from the shareholders if the capital reduction is approved as part of the special resolution?
It wouldn't be. So I guess this comes from a part wherein Mr. Vikas would have seen any of that procedure. So what happens is, in case you have given the NCLT consent letter along with the application of the first motion, there will not be any meeting of the shareholders required. But now let's suppose NCLT is not satisfied with those consent letters and feels that there is a meeting required from the shareholders, then it will direct the meeting of the shareholders to be conducted. So this is a very case-to-case basis.
Yeah.
Okay. When do you prefer the reduction of the capital instead of the buyback?
Para sir, if you want to take it.
Yeah, generally, if the company has got the accumulated losses, they want to restructure, improve upon the capital structure. That situation, the reduction of the capital is actually taken back. Otherwise, the company is, a company is having a liquid funds, liquid cash, etc. They want to the restructuring, in which case they need not go to the reduction of the capital directly. They can go in the other route. One of the route is the buyback, because much will depend upon the company's cash position, what they have, and again, whether the company is a loss-making company or the profit-making company. The situation will depends upon what the scheme you want to go for it. That's what I feel.
Correct.
Mr. Atul, you want to comment? When do you prefer reduction of capital instead of buyback?
As Bala sir said, to accumulate the losses. And I think it's one more thing we can say to preserve the dividends to give in the future to our existing shareholders. So we can do for this also.
Right. Yeah, next. Thank you.
Yeah.
Have you seen precedent where the NCLT has done away with the requirement of obtaining certificate from statutory order and fine with proceeding with the certificate? Yes. Apart from the listed entities, we have done that in our cases wherein you know NCLT has done away with the statutory requirement, statutory auditor certificate, and gone ahead with the any other certified auditor for
Yeah.
that part.
We are a material subsidiary unlisted company.
There is another. Why Big Four will take more time to certify list of creators? So we've discussed this before.
Yeah,
Yes,
yeah, that
they
is why I
have
skipped
their
that.
own process, their own governance issue that, soft.
Their internal approvals, their internal procedural things take a lot of time. And rather the client is only not ready to go ahead and unse wo baat karna, discuss karna for that part gets very difficult for that part to get enough. So rather they would.
We can say that why Big Four is taking more time compared to others. See, they have their own process.
No,
They have
no, yeah, that is right. You are right, because they have the multi
an
layers.
internal system, and there is a reason for that. They are not doing intentionally.
Correct.
They have their own international parameters. They have big clients, lot of exposures, so they have to protect their own interest. Not only the all stakeholders, so they have their own very much parameters. So that's why it may take time. So it's
Yeah.
everyone knows we have to accept that. It is
Yeah,
their parameters. We
in
have
the
to
beginning also we talked about the Big Four actually, because they have the multi-layer approval and applications and other things and all the things. So that is their own internal system and procedure. If you want to live with it, you live with it. Otherwise, you'll have to find out. But if the regulator wants only your statutory auditor, if the Big Four happen to be your statutory auditor, there is no other way.
Yeah, next.
Okay.
Provide a copy of the
Every
presentation.
time we actually keep getting these questions, I have been repeatedly answering it. PPT is never made available to the people because the recorded webinar is available, that is actually disseminated, which contain the PPT. So it is not possible to share the PPT separately individually. So please watch the recorded webinar, which is distributed
On YouTube, I believe.
Yeah. We are material subsidiary unlisted company, and our holding company is a listed company. Want to know applicability to the SEBI LODR for a subsidiary and also for the holding company to comply reduction of the share capital at the subsidiary. This is the big procedure because we are not discussing today on LODR. It is a big topic itself. It will take time. Probably we'll have to have a separate session for particular thing. That is why our presenter has touched upon the SEBI LODR regulation will be complied with. He has shortlisted some of the issues which are coming up. So probably this question we will not be able to satisfy you at this webinar.
But we can just say that, Mr. Atul, you would like to attend this?
Yeah, so
Ma'am, I just gave him what kind of a regulation is attracted. Regulation 24 is attracted for the listed entity and material subsidiary. And for apart from the holding company, they have to intimate under regulation 30 about this reduction of share capital to the exchange. But
Yeah.
there's a law, as Bala sir said, it is a very long process, and there are more complexities in as per the LODR. So it is a separate subject, ma'am.
But we
Right.
can say that way that holding company which is listed will be governed by SEBI LODR, and subsidiary will be governed by Companies Act being unlisted.
Yes,
In
ma'am.
fact,
And it will follow reduction for capital.
Atul handled the listed company, and he can be contacted. He will tell you what is it, because he is practically involved in the listed company's reduction.
Yeah.
Okay.
So subsidiary will follow reduction, and holding will follow the LODR relevant to that. Yeah.
Yes, ma'am. Yes, ma'am.
Creditors in, yeah.
creditors includes lending bankers,
Yeah.
Yeah.
secured and unsecured both.
Okay.
And a capital reduction by paying of equity share liabilities on reporting date. If the legal process is yet to be completed, then what would be the accounting treatment of capital reduction being adjusting event?
We are taking.
The capital reduction is accounting and taxation is taken separately.
We're taking
I
up very
think this
shortly.
question will be answered separately here when we see the presentation.
Yes, we are taking up very shortly.
Yeah.
Yeah.
Is it the standalone reduction of the share capital under 66 does not require any separate scheme and is to be carried out as part of the one single petition?
It can be. A standalone reduction of share capital can be a separate scheme altogether. It is not required that it goes along with some other scheme. It can be filed with as in a separate scheme altogether as a part of one single petition.
It be that specific provision was a general provision under Section 6 versions 230.
I think Dweep already explained this, right?
Yeah, this is what he has explained actually.
Yes.
Right?
Can you please
Yes.
mention the?
I believe if this is on the point of view of the merger scheme and this, so I believe it is that part only as a scheme of arrangement or something.
Can you please mention the precedent where NCLT Mumbai has approved selective capital
We have
reduction?
covered this, given that,
I think he has given the case, I think.
yeah.
Can we do selective reduction and share capital
answered.
shareholders are not result? That also you answered.
Yeah.
Yes, that I believe in that case law itself has been answered.
Yeah.
Yeah. Can't the small unsecured creditor be paid beforehand before filing the scheme? Nothing like it. You can do it.
I would rather
If you are able
suggest.
to do it, there is
I would
nothing like
rather
it.
suggest this only. I would be
Yeah.
the person to do that.
There is a better way of doing it instead of bothering it.
Nothing better than that.
Yeah.
Valuation is
Value-
mandatory, even if it was set. It is settled in face value by obtaining approval for the scheme. Valuation is mandatory, even if it was settled in a face
I
value.
think he's answering rather than question.
So valuation will be mandatory in any which case because NCLT will require a fresh valuation for this approval. So it is mandatory.
How much time it takes that we just talked about it.
We've discussed that at length.
Is the reduction of CCD permissible under the section 66?
This is compulsory.
Compulsory convertible debentures.
Yes, it is.
Whether the reduction of period of redeemable preference share amounts to reduction of the capital.
We've discussed this.
Yeah,
We discussed it.
the above that we talked about it. Preference share can be redeemed only from the free reserves or fresh issue of these circumstances. Can we say that it is a long-term borrowing? Yeah, this also we talked about it in fact.
Preference share is talked separately.
Yeah. Can the reduction of
Buyback
preference?
tax.
Yeah.
So I believe this will be handled by this only by Harshada itself.
Can reduction of the preference share be subjected to buyback for under 115 QA?
That Harshida will cover.
Okay.
And sorry, the answer, if reduction of CCD is permissible. Cumulative convertible debentures. So,
Correct. Yes.
so it is like the same thing, conversion of equity into preference shares. So
Preference share.
his
Correct.
question is
Similarly for this.
cumulative convertible debentures which will be converted into equity in future, whether that tantamounts to reduction of capital, it covers very complex issue. We have to check that the terms of the issue and accordingly we check that it is not a simple one-liner question and one-liner answer. Mr. Atul, you want, because see, it is convertible debentures. So it will be converted into equity. Before the equity is getting issued, they want to reduction of cumulative convertible debentures. So it's require a lot of checking and process.
Ma'am, it is a very crucial and very complex situation. Is that there are a lot of case laws is who favor is considered as a capital deduction, who is in favor of there's not a capital deduction. So there's a lot of case laws is
A lot
there.
of study and questions and law.
It totally depends on the companies to company and their what they're trying to do for this, their scheme and
Facts
their
and circumstances will be required in that case. Yeah.
Is there any time gap to be maintained by the company reporting to capital reduction for further raising capital subsequently?
If reduction is there, then the same kind of shares cannot, there is a provision, no, that I think, Mr. Atul, that is similar cannot be raised for some period.
Yes, ma'am. We can't. For
Yeah.
I think 1 year.
For year or kind of thing, same kind of shares.
I think for a year or something, that's a provision. Is there.
Yeah.
Conversion of CCD into the share capital will
That
increase
we
the.
cover, that we cover.
Okay.
I believe in that.
I think that's all the
Yeah.
questions which are in the chat box. We are done with that.
Mr. Parekh, this conversion of CCD into share capital, I said that before conversion they want to do, then it is. If it is converted into share capital, then we can do reduction of share capital after it is converted. The question is before conversion. That's why we said that it is a facts and circumstances. If it is converted into share capital, it is share capital. Then you govern by the reduction of share capital we discussed. Okay. Yeah, Arshida, you can start.
I'll just take the lead.
Sorry?
I'll take a leave then for this part. Let Harshada be there.
Yeah, please. But you be there.
Yeah, but yeah,
Don't
you'll
leave
have
the
to
don't leave the
help
webinar.
me in. Yeah.
Because some question
Absolutely
will
not.
be asked.
No, absolutely not.
Yeah. Yeah, Arshida, please.
Hello.
Yeah, you
Hello.
can.
Good afternoon, everyone.
Yeah, good afternoon, dear.
Yeah. Thank you, ma'am, for giving this opportunity. And yes, Deep, I think you'll have to present your slide for me.
The slides are in
Yeah,
that
yeah.
presentation only.
Yeah.
Yeah.
Please start. Yeah,
Yeah. Please help me with the next page.
yeah, please.
Yeah. So we are covering the accounting and tax aspect of the share capital reduction in India. In this slides, we'll explore the Ind AS and IGAP, Companies Act, and Income Tax Act. So Dweep has covered next. So Dweep has covered most of these things, like understanding the share capital reduction. So I think this is nothing to explain much in this, but yes, in a legal framework. Wait. Uh, yes. So the purpose is very much clear that it is for accumulating the losses, return the excess capital to the shareholders, or adjust the company's capital structure to have a better presentation of the ratios of the financials. So in a legal framework, we required the approval from the shareholders, board of directors, and NCLT. Again, this consideration in this, the careful consideration needs to be done of the accounting for the tax implications that we'll see later. Dweep, next. Sorry. So we'll see how the presentation goes with the Ind AS. So the key provision for the Ind AS is requires that entities to present the analysis of the expenses using classification. The classification is just like we have presented in the example that before reduction the share capital was 1 lakh, and if suppose we are reducing the share capital by 50,000, so after reduction the share capital is 50,000. With the adjustment note, the company reduces the share capital by 50,000 to restructure its equity base. That's it. This is the financial statement presentation as per Ind AS 1. Yeah. So this is the event, which is if suppose this event happens after the date of financial statement. So that is, for example, if at all we consider that 31st March 2024 is our last date, is the financial closure date. So now this particular event has happened after that. So I think this is the answer for that question. So the financial statements need to present this before the signing it by the auditor. For example, the reporting, but therefore the financial statements are authorized. Yeah, the date of authorization and the date of closure of the balance sheet. If at all this event is happening in between this period, so we'll have to mention under disclosure that this particular event is happening. Yeah. As per Ind AS 32, the financial instruments presentation is just again the same. The classification needs to be done and the disclosure needs to be given. So the disclosure note will be following the recent reduction of the share capital. The company reviewed the classification of the financial instruments and determined that no reclassification was required. The equity and liability components remain unchanged. This can be the example of this presentation. Yeah, the IGAP is more of the another explanation, the more explanations about this. So IGAP AS1, the disclosure of accounting policies, there is actually which will, as per AS1, the fundamental assumption is always that it is a going concern, consistency is there for the company, and accrual in the preparation and the presentation of financial statement. So this is kind of the audit report. These things contained in the audit report. So CA needs to disclose all these things. Then the policy disclosure, the clearly disclose the policy, accounting policies for the reduction of share capital, including the basis for recognition and measurement. So the example of the policy notice, the company follows the accounting policy for reducing share capital only with the approval of the shareholders. So yes, the approval of shareholders and all needs to be taken. Authorities, relevant authorities needs to be taken, like an NCLT, and proper reflection in the financial statement. That is the ensuring proper reflection of the financial statement. So that is the policy note needs to be prepared and disclosed. Next. Yeah, again, under IGAP also, this is the same event which needs to be taken care by in the balance sheet date. After the balance sheet date, suppose this is happening. So we'll have to subsequently disclose this. That disclosure note would be with the disclosure note. The reduction of the share capital was approved by the board on this date, and subsequent to the balance sheet date. What is the balance sheet date? Which is your last day of the like financial period. So Schedule 3 of Companies Act 2013, I think already is covered by Dweep, but still the statutory requirements are the Schedule 3 mandates the financial statement presents the true and fair view of the company's affairs. The balance sheet must include the detail under equity and liability with the separate line item for share capital, as we always present that. Presentation of the reduction. The reduction must be clearly presented in the equity section under share capital. Comparative figures should be adjusted to reflect the reduction. With the example we have given here, the example presentation should be again before reduction share capital 1 lakh, after reduction 50,000. So the adjustment note, the reduction of the 50, this is the same. Yeah, yeah. So presentation under financial statement is this, that is under in the balance sheet, that is present reduced share capital under equity and liabilities, which we have already seen. So example, if the original share capital was 1 lakh and reduced to 50,000, so show 50,000 as a share capital in the balance sheet. Then statement of changes in equity, show the movement in the share capital due to the reduction. For example, the reduction of 50,000 in the share capital clearly presented at the separate line item, as we have seen before also. Then notes to accounts, it should be mentioned that the share capital was reduced by 50,000, whatever the amount is, to improve the company's financial structure and the performances. So whatever the reason is decided by the board of directors or in the meeting. Yeah. This is again the required disclosures in the financial statement. So nature, what is a nature? That clearly explains that rational reason behind the share capital reduction, such as eliminating accumulated losses or returning the excess capital to the shareholders. Whatever the reason is, that we'll have to mention. Amount and impact, specify the amount of reduction that we have already seen in the previous slide. That financial impact on the company's equity structure and overall financial position that we are showing in the balance sheet. Then regulatory approvals, mention all the approvals which we have taken, including those from shareholders, board of directors, and NCLT. And comparative figures, adjust and disclose the comparative figures if necessary, ensuring consistency and comparability across reporting periods that we have already seen in the AS. Yeah. Auditor's checklist would be for the share capital reduction is this resolution verification. Whatever the resolution we have passed, that should be verified and it should be noted in the audit report. Confirm the compliance with all the statutory requirements and obtain the evidence of the approval from the NCLT. Then financial statement review, that ensure the proper presentation, which we have seen how to present, that should be checklist. That should be checked by the auditor, and including balance sheet, statement of changes in equity, and notes to accounts. These are the three places wherein the effect will come. So impact assessment, review the impact on the equity sections and ensure the proper reflection in the balance sheet, including any other adjustments to the reserves or retained earnings. So yes, again the answer to that question, whether we can adjust the reserves, yes. So the answer for that is first we can utilize the capital reserve, the general reserve, and then if at all any other reserve we have. Yeah, then we'll see the income tax impact under section 222D of Income Tax Act 1961. So your provision is there. So any distribution to the shareholders by company on the reduction of its capital, to the extent to which the company processes the accumulated profit, whenever capitalized or not, shall be deemed to be dividend. So it will be taxable under as a dividend. Then implication, the portion of the capital reduction corresponding to the accumulated profit is treated as a dividend distribution. So potentially subjected to the dividend distribution tax. Then example calculation is this. If the company with the accumulated profits is 1 lakh, with the accumulated profits of rupees 1 lakh, reduces its share capital to rupees by 50,000 and distributes its amount to the shareholders, then this 50,000 will be treated as the dividend for the tax purpose. Then
So that means,
the tax planning.
that means today's tax laws, although it is a deemed dividend distribution, the tax will have to be
Yes.
paid by the receiver in the hands of the shareholders. Correct?
Yes, sir. Yes, sir. The
Because
tax planning would be.
Yeah. Tax
Sorry.
liability will
Yes,
be
sir.
the
Continue.
person who is receiving it, that is namely the shareholders.
Correct, sir. It will be taxable in the hands of shareholders.
Yeah.
Companies should carefully consider the tax implications of capital reduction, especially when they have substantial accumulated profits. So this will impact their profits and changes in the profits. Next slide, the companies, the income tax impact under Section 45 and Section 50 CA. Section 45 is a capital gains. Any profit or gains arising from the transfer of capital asset are chargeable to income tax under the head capital gains in the context of share capital reduction. If the shareholders receive an amount exceeding their cost of acquisition, it may result in capital gains. So this is the answer for your question, sir. So this will be taxed under capital gain. Then Section 50 CA is a fair market value. So if at all the fair market value is the higher than the cost of acquisition of the shares, then the fair market value will be considered. For an example, if the shareholder receive 50,000 for the shares with the cost of acquisition of 30,000, they will have the capital gain of 20,000. However, if the fair market value of the unquoted shares will be 60,000, the capital gain would be calculated as 30,000 despite of the lower actual consideration is received. So this will be taxed as the capital gain will be considered as 30,000. Yeah, that's it. And this is what is the income tax implication in the hands of shareholders.
Thank you, Arshida. Exactly, you have covered everything, the capital gains and all the questions of accounting treatment. So whatever questions you have already answered during your presentation, wonderful.
Correct.
That.
Yeah, I was reading, I was going through, and so yeah. Thank you so much.
One is asked whether recipient will pay tax on deemed dividend or on capital gain. I think
Capital gain.
Capital gain. Last slide was little fast, that's why this question came. Okay.
Okay, ma'am.
Last slide it is capital gain. So I think some people has raised the hand. We will allow them to.
There is one question is also put up here saying that just wanted to know if the CCD standalone can be reduced.
Mr. Bala, what I said, no, that same is telling. He wanted to know if CCD need to be reduced, then what it is. Okay. So whether it will apply to reduction of share capital or not. So I said that only.
Okay.
And
Okay.
I think Alicia and Pooja has raised the hand. I don't know.
So there is one Nishi's raised the hand and
Yeah,
Joyce is raised the hand. Yeah. I can see here Joyce and Nishi. Yeah, you can speak. You can unmute and speak, please. Nishi Shukla.
Nishi Shukla is there? You can unmute.
Any one of you? Joyce? Joyce Naroda? Nishi? Any one of you can unmute and talk. I think this unmuting is enabled.
Also, in the chat box, we also missed out one of the questions that had accounting perspective.
But
I will just check.
Nishi said it's.
No, we said actually that to be said because when we talk about the accounting in taxation prospect, that will be answered. That is why we have not taken that.
Yes, so we can take up that part.
But I think Harshida answered.
She has already answered that.
When she was
Yes,
giving
ma'am.
Yeah, her presentation answered that.
All right.
Yeah.
Yeah, she got the.
I think both of them
She
seems
got
to
the
be not,
answers.
both of them seems to be not there because they are not.
No. Nisi said that she got the answer, so.
Okay,
Yes,
that-
might be she's.
okay,
Yeah.
okay. How about Joyce?
Can a company with negative accumulated profits undertake capital reduction? Negative capital.
Yes, they
Negative
can.
accumulated profits
Sir,
means it is the loss, no?
Correct.
Yes,
Accumulated loss, you are
Yeah,
giving a different color, isn't it?
yeah,
Yeah,
okay. Mr. Nirmal, under capital reduction by paying equity, no, I think this is the, is this address? I am not sure. Under capital reduction by paying of equity share liabilities. On reporting that if the legal process is yet to be completed, this is answered, no? Harshida, if you can just check.
Yes, ma'am, this is answered because we have already taken the approvals from the authorities. So we have to disclose it under the balance sheet,
Okay.
the notes of accounts. Yeah. And this I've answered. Further, the liabilities are not paid off, then we have to adjust that also I've answered.
Yeah.
The
Yeah.
to the extent the consideration is considered as a deemed dividend, is withholding required from the company's end?
Yes, that she's answered.
Yeah. Yeah, Ms. Harshida, your little one also want to be on a screen.
yes, ma'am, he is. Sorry.
Yeah, absolutely not a problem.
Okay, I think we answered everyone and that's all. And thanks all participants for attending. Thanks, Mr. Atul, for your time and sharing your valuable experience and knowledge of handling the creditors and the shareholders in the way how it is difficult and one has to take care neutrally to address them. Thanks a lot for your time and sharing the knowledge. Thank you, Dweep. Today's presentation, initially it was looking that participants will get bored with the process, but you have covered it very interestingly by all decided cases and half the questions were answered in the presentation itself. Wonderful. And Harshida, you also covered the questions in the answers. People were waiting for that.
Thank you, ma'am.
Thanks a lot. As usual, Mr. Bala, your extra comment was really helpful. Your sharing experience. And all participants, thanks for all your participation. Thanks a lot. Thanks, everyone.
Dipti and also all the participants, although I thought it is a very non-common subject which is actually there, but you look at the time now, time is 1:15, look at the participants, almost about 85 people still. So which definitely shows there are a lot of interest is there in this particular topic, people want to learn. So looking at the learning attitudes of people, I am very highly impressed, and the way in which it is presented, the way in which it was explained, and especially the practical experience added by Mr. Atul, which is very helpful. So really speaking, I personally gained a lot of things in today's, even I had certain doubt which I raised on and off, which I got to think that the latest development, our company secretary come advocate, who is definitely answered, which shows the current updation. All said and done, the session was very wonderful. It is really enhancing knowledge. Thanks a lot to everybody. Thanks to Atul. Thanks to Joshi. Thanks to Arshita.
Thanks.
Wonderful.
Thanks.
Thank you, sir.
Dipti, I am not personally thanking because you are always wonderful. So I don't have to separately convey you my thanks to you.
No, of course not. Thank you. Thank you, Arun. Thank you, Mr. Atul.
Thank you.
Have a good weekend. We'll meet yet again in the next month in some other new session. Thank you.
Thanks.